Oh, pardon me.
No, that's his. Well, no, that's he's an attorney. That's his stuff. He's putting it by his stuff.
Oh, you just talked
No,
about
no, he's
that.
not.
I didn't know.
No.
Everyone, please be quiet. Order in the court. Everyone may be seated. Let the record reflect that the court is back in session in cause number 323-227. Case is style of state of Texas versus Samuel Hayden Falk. Let the record also reflect that Mr. Falk is present in the courtroom with his attorney John Macy. Let the record reflect that the state is present with Assistant District Attorney Kyle Gasper and Attorney Andrew Hubel. Let the record reflect that the jury is now present and seated in the courtroom. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
Ready.
Okay. Yesterday, the state rested. Mr. Macy, you may proceed.
Thank you, Your Honor. This time I'd like to call Deborah Falk.
Deborah Falk.
Yes, Your Honor.
Deborah Falk. Deborah Falk. Ms. Falk, would you please come forward? Ms. Falk, would you please raise your right hand? Ms. Falk, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Ms. Falk, you may put your hand down. Take the seat in the witness stand, and the bailiff will attach the mic. Okay. Mr. Macy,
Thank you, Your Honor.
you may proceed.
Ms. Falk, I'm sorry, did you state your name for the record?
Deborah Williams.
Ms. Falk, my name is John Macy. I'm Samuel's attorney. You know that, right? And what is your relationship to Samuel? Your mother. So that's a silly question. So I take it you've known him all his life.
Yes.
Are you familiar with an incident that happened on or about May the 11th of 2019?
Yes, sir.
And how are you familiar with that?
Well, I was notified by an employee at the jail that he had arrived at the jail from the medical center hospital by the accept score.
Okay.
That he was arrested for DWI.
I see. Okay. Now, We've heard, the jury has heard testimony from the officers that responded to the scene. And, so they indicated something to the effect that Samuel was in a, certain vehicle. Do you know what vehicle he was in?
Yes, it was a Toyota Corolla. I don't remember the year. It was,
How are
been
you,
5 years, so 20 maybe.
are you familiar with that
19.
particular vehicle?
Pardon?
Are you familiar with that vehicle?
Yes, but we had just purchased it, so we
Okay.
had it about a month. It was used. It was a
And
2018 or so.
do you know, if you know, who was the registered owner, title owner of that vehicle?
I mean, I was.
So you bought the vehicle, correct?
Was buying the vehicle. I hadn't paid a note on it yet.
Understand. But, who was if you know, was the primary, driver of that vehicle?
I was.
Because the incident was traffic, wreck, and you weren't driving, Samuel was driving.
Yes, sir.
Okay. Do you know how it was that Samuel came to be driving that vehicle on May the 11th?
Yes, sir. We only had one vehicle. And he and I were on our way to take care of some business in another house that I owned, but that I rented. And I got a call from my home, from my mother, who said she was scared. So I let Sam drive me back to my mother's, and then he took the car to the other house. And
Okay. Do you recall approximately what time that was?
between 9:30 and 10, Saturday night.
What, if anything, were you doing prior to Samuel dropping you off, that day?
Sam and I both were working on different properties. We had a tornado early that morning. And he was staying at his stepfather's house, and he helped neighbors remove limbs and work on the yard. There were a lot of limbs down. I was at my mother's, which is about 10 minutes from his house, and we had a lot of limbs down, so we were both working on properties. And I was with him most of the day, from about 10 in the morning.
Okay, so clarify that a little bit, because you said, oh, I know that Sam was doing this and I was doing this, but you said you were about 10 minutes apart. So how do you know Sam was doing what you think he was doing at the one house?
We were back and forth. My mother was ill, and so was my daughter, so I was having to run back and forth between the two houses, say every 30 minutes, maybe more often, to check on them. And he was staying with his stepfather, who was also ill.
Okay. And is that the house he was at when he, cleaning the limbs? His stepfather's house, or was he
Yes,
somewhere
he
else?
was at his stepfather's house. He was also at the house in Central Gardens. And then
Sorry.
he was
What?
also at my mother's home in Central Gardens. And we had another house that we rented in Nederland. So we were at all three places all day,
Okay,
pretty much.
I think you said that there had been a tornado that day,
Early in the morning, yes, sir.
Okay.
On May 11th.
and that caused the debris in all three places.
Yes, sir. And there was a lot of flooding as well. So I wasn't real familiar with the car, but he had to be very careful that we didn't hydroplane.
Okay.
It came up to the door.
So inside the vehicle, when the police got there, there's been testimony that they found some pill bottles. Do you know anything about those?
Sure, we had to take the pill bottles to the pharmacy to have refills because the computers were down. It was King's Pharmacy, it's CVS now. We had to park about a block away and walk to the pharmacy, and we took the bottles with us to have them filled. Some
Okay,
of the scripts were mine, my daughter's, and Samuel's, and my ex-husband,
okay,
which I was responsible for having all the prescriptions filled
Yep.
every month. And so they were in my car, of course.
my understanding from the testimony is that there was one bottle that had something whatever the prescription was scratched off and something written that claimed to be Klonopin. Do you know anything about that?
Well, that could have been my son's prescription, but it's also my daughter's prescription. She took Klonopin at the time.
Okay. And then there was another prescription, bottle that the testimony was had 5 pills that the officer believed was Adderall. Do you know anything about that?
Yes, sir. We both have prescriptions for Adderall.
When you say we both, who are you referring
And
to?
I both have prescriptions for Adderall.
Okay. And I don't know if this is appropriate, but do you know what the reason for the prescription of Adderall is?
Yes,
What is,
well, mine is for ADD since I was a teenager, and later on, when I started doing shift work at the hospital, I needed to stay awake on alternate shifts. So low dose. Samuel's was something different,
and
partly.
I meant to ask you this already, but could you tell the jury a little bit about your background?
I've been a nurse for 40 years. I work mostly in the emergency room. I've done a lot of different nursing because I had to work 2 jobs.
Your Honor, may we approach?
So,
Mr. Mason, you may proceed.
thank you. Ms. Falk, I just wanted you to give a little bit about your history, of, you know, your life. You said you were a nurse for 40 years? And where did you go? Were you licensed?
Yes, sir, I was an RN.
An RN?
Degree from Lamar.
I'm sorry, what?
I have a bachelor's degree in nursing from Lamar University. graduated in December of '83.
Okay, uh, and then and then I think you said you worked in a lot of different emergency rooms?
Areas of nursing, there's many different, careers, paths, and I probably chose all of them. But primarily I started with the emergency room at San Luis.
It's St. Elizabeth
Yes, sir.
in Beaumont?
Yes, sir.
Okay. All right. Talk more about the vehicle, okay? The Toyota Corolla that Samuel had the accident in was yours, correct?
Yes, sir.
The pill bottles inside of it, do you know whose those were?
Well, it was my car. I had possession of the bottles. They were mine.
Okay.
No, I don't know which ones. Like I said, we don't have to do that anymore because everything's computerized. You go to the doctor, they fax the script over to the pharmacy. So you don't have all the bottles. They get refills.
Okay. So in 2019, are you saying that you needed the bottles?
That one day, because the computers were down due to the hurricane, I'm sorry, the tornado. They didn't have electricity at the pharmacy and it was flooding. And they closed at 2 o'clock in the afternoon. Some of those had to be refilled before the weekend. They're closed on Sunday.
Okay.
So
Because,
the filled bottles were where they were supposed to be with the different features. I delivered the ones that need to be delivered.
okay, so the ones that were empty just were the ones that you had showed earlier to get the prescriptions refilled?
Yes, sir.
Um, now, there was some testimony that had to do with Samuel fiddling with the key. Are you familiar with the keys, how the keys worked in your Toyota?
I don't know. I don't remember. I don't have keys to my car now. I was fob, and I don't think we had fob then.
I guess what I'm asking you is, if you know, do you know whether when the car's turned off, you can just pull the key out? Or whether it's stuck in? Do you know?
I don't think it would stick if it was supposed to come out. I don't know.
Okay.
I just don't remember what the car mechanism was.
Okay.
I didn't have a car very long.
It had a display that you could touch. The car did, right?
I'm assuming.
Kind of, well, it was your car, right?
Yes, but that was
I mean,
5.5 years
understand.
ago, and I only had it a month, and I had several cars since.
Okay. Do you recall whether or not on the dashboard over where the radio or might be in a lot of cars, that there was a screen there in that car? You don't remember? Do you know whether or not it had a way to have a phone number in that so that you could hit a button on that screen and call someone or not?
I didn't utilize that, it was there.
Okay, so as far as you know, it didn't happen.
Well, I never used it.
Okay. Now you're Sam's mother, right?
So,
And you're a nurse. Does he have some issues with his mouth?
yes, sir.
Uh, and how do you know that?
You mean currently with accents or infections or Is that what you're talking
Yeah,
about?
well, let me back up. Back in May of 2019, did he have issues with his mouth? Do you remember?
He had braces that required about 4 years, so there were always issues with the smell.
Okay.
And he bit his tongue off, I think, that evening. When he hit, supposed to hit the steering wheel. His mouth was bleeding.
Do you know whether or not he had problems with his with his teeth that caused him to need some type of medical procedure back then?
Remember any medical procedures during that time. He had had some prior to that and then after that, but it was usually related to crowns and related to the braces and the gums. He had something done with his gums or whatever.
Because I know you weren't in here when, and so you've never seen a video of him, or have you, other than, or did I show?
We didn't show it. I did see the first video.
You saw a video of the car wreck?
Yes,
I say the car wreck. You saw the video of the police when they went and talked with Samuel when he was in the car immediately, when they were responding to the car.
yes.
You saw that video. Okay. So you said that at some point Sam dropped you off at your mother's house. And I asked you what time that was, and you said about 10 o'clock. Is that right?
Between 9:30.
Okay.
Just he was trying to make it.
Prior to that, had you been with Sam for any period of time?
Yes, sir. I had gone over to the stepfather's that morning about 9:30 or 10.
Okay.
And I got things settled down where I was. I went over there to help.
And then how long were you with Samuel that day?
His stepfather's head injured and blind, so he requires a lot of assistance, and he couldn't help Sam with a lot of the tree limbs and just cleaning up everything. We didn't have any other help.
Do you know, or did you ever witness that Sam drinking that day?
No, sir.
Did-
Sam was forbidden to drink in front of me or to have liquor in the house or any of the houses we were in.
Okay. If Sam would have been drinking, do you think you would have known?
Immediately,
And what makes you say that?
because he becomes very violent when he's drinking.
Um,
And he would have had to purchase it. I didn't give him it. He had no money.
um, let me talk about, your you watched the first video, where the police officers came, up and, it was actually Officer Collins, and in case that was his name. I doubt you knew that. Officer Collins,
Object, Your Honor, if she's testifying to something that she just saw via video, she was not an eyewitness of, she does not have the personal knowledge necessary to testify to that.
Mr. Mason?
Your Honor, I'm just setting it up, I'm gonna ask her, whether, because she, because of her background as a nurse, whether she saw anything,
And that would be an issue that we spoke on previously.
um, if you
I
want.
mean, I was just saying, what's your response to his objection?
Our judge is that, since she watched the video,
Okay,
She saw
his
the
objection was
actions.
hearsay.
I'm sorry, what?
His objection is hearsay.
Hearsay. I'm not asking what she what she heard someone say. I'm asking her what her opinion of what she saw Officer Collins do.
And I also have an issue with that if she's going to testify based on her experience and particularly if Mr. Mason is going to qualify her as an expert.
All right, your objection is sustained. Yeah, you can move on.
Your Honor, we're gonna approach.
Well, the process.
You saw the video of the car wreck, correct? You saw Officer Collins go up to Samuel and start asking him questions, right?
Yeah,
What was,
the objection was going to be that she's testifying to something that she doesn't have personal knowledge of.
objection sustained? Thank you.
Have you, as a nurse, ever learned about head trauma?
Yes, sir.
What types of symptoms, if you know, might head trauma cause?
And so, how bad the trauma is.
Your Honor, I'm going to object that Mr. Reese is asking questions about her expertise without certifying her as an expert.
Objection sustained.
Ms. Paul, you were you got a bachelor's degree in nursing from Lamar University.
Yes, sir.
In what year?
December of 93, 83, I'm sorry.
December of 83. And did you, and I think you said you were RN. When did you, get licensed as an RN?
March of 84.
March of
They
84.
split boards and then they issue you a license. It happens much faster now, but back then we had to take a written test and wait for it to get graded.
What courses did you take?
The sciences that were required to general, history and medical and the nursing courses that were required. For all basic. For the children and pediatrics.
Were you taught to, as a nurse, what's your job when you're working in a hospital with respect to dealing with patients?
Depends on what your assignment is and what's required of the patient. Everyone has different needs. Mainly, I prefer the emergency room.
Okay, so
It just-
is your job to care for patients?
it's a-
To look at the patients, and if you see something, your job is to identify potential problems, right?
It's a,
And then if you see a potential problem, you're supposed to convey that problem to a doctor
yes,
so that the doctor can treat that problem. Correct?
correct.
And how long did you do that?
Different environments for 40 years.
Okay.
I wasn't always a hands-on nurse in the emergency room. My career path was in case management for the emergency room, and that didn't require hands-on care. It required placing patients in the proper places, discharging them, transferring them.
Okay,
And if I saw something that the nurse meant, I gave the information to the nurse or to the doctor for them to treat.
so how long how many years did you, if any, did you work for, actually work with patients in a hospital environment?
40 years.
Well, now, it could have been 40 years because you said you changed career paths and you went from working in an emergency room to working with administration, doing other things.
I was still in the emergency room.
But are you saying that you worked with patients the whole 40 years?
Pretty much. Yes, sir. That doesn't mean that we have hands-on care. It could have been any number of things.
Okay, so how long did you do hands-on care as you were
It's
working?
interspersed across those 40 years. My last assignment, I was doing hands-on care. But before that, I did both. I worked 2 jobs usually.
Okay, did you do those 2 jobs simultaneously?
Monday through Friday was one, Saturday and Sunday was another. I worked 12-hour shifts on Saturday and Sunday. I wasn't isolated because then I wasn't subject to Houston and worked for Herman Trauma Center and Methodist. triage also in those areas where I had to assess patients as they arrived in the emergency room.
Your Honor, may we approach?
Mr. Hill? Okay, ladies and gentlemen of the jury, there's a matter that we need to take outside of your presence. Uh, please stand and you can follow the bailiff into the hallway. Ms. Falk, you can still sit there. Okay, take care of this matter outside of the presence. Like You may be seated. Jefferson County Court Law number 2 is back in session. The court is in session in cause number 323-227. Case is style of State of Texas versus Samuel Hayden Falk. Let the record reflect that Mr. Falk is now present in the courtroom. Let the record also reflect that Mr. Falk is present with his attorney. Attorney John Macy, State is present with Assistant District Attorneys, Attorney Kyle Gasper, and Attorney Andrew Hubel. And I think Mr. Macy, you may proceed.
Thank you, Your Honor. Ms. Falk, in your experience, is it appropriate for somebody to shine a bright light in the eyes of
Going to,
a?
Your Honor, can I review my hearsay objection?
I haven't finished my question yet, Judge.
He says it appropriate. Okay, go ahead and finish your question.
In your experience as a nurse, would it be appropriate for someone to shine a bright light in the eyes of someone who might have head trauma?
A nurse may have been trained or educated not to do that, but the general public might not. Not everybody knows that shining a bright light in someone's eyes that has head trauma can cause all kinds of problems, including seizures.
You were with Samuel earlier that evening before the wreck. Yeah, I think you already testified to that.
Yes.
And just to refresh my memory, you said he wasn't drinking in your presence. Is that right?
That's correct.
Okay. Ms. Gasper, the witness is yours.
Good afternoon, Ms. Falk. How are you doing?
Good.
I have a few follow-up questions for you. Now, you're Samuel's mother, correct? And does he live with you?
No,
Did he live at you in May of 2019?
no,
Do you support him financially in any way?
yes,
You mentioned when Mr. Macy was asking you some questions that he didn't have any money to buy alcohol. Did you provide him with his financial abilities to purchase things? He didn't make money on his own?
at that time, no, he didn't.
No, so you gave him the money that he needed. You also mentioned, however, that he was going to HEB after you dropped him off, or he dropped you off, excuse me. Did you give him money for groceries or something else that he was getting at HEB?
Yes, and they found it in the car after the accident.
Okay,
Officers found it. It was, in fact, they found it to make sure the money was there.
okay,
Not because of them, but just to make sure nothing was spent.
yes, I understand. You said he dropped you off around 9:30 to 10 o'clock that night. Was that May 11th, 2019? And did you ever hear from him after 9:30 or 10, whenever he dropped you off?
I spoke to him around 10. He was on his way to our rent house, to feed the dogs and straighten the house, and then decide whether he was going to HEB or not. I didn't hear from him after that.
Okay, and the next time that you had contact with him or someone with him was when the officer told you that he was being transported to the jail?
Actually, the jail called me
The jail called
after he
you?
was transported,
Okay,
about 3 a.m.
Okay.
Of course, I've been calling around looking for him, and
but you hadn't gotten in contact with them until the jail
I
called
didn't
you?
know where it was.
No further questions. I pass the witness.
Okay, Mr. Macy. Okay, may this witness be excused?
So,
State,
Yes, Your Honor.
okay. Ms. Falk, you are excused, and as I mentioned to you earlier, you are under the rule. You're allowed to leave the courtroom, and you cannot come back in the courtroom unless the bailiff or myself would allow you, ask you to come back in. Now, if any of the attorneys have any follow-up questions, I'm sure, Mr. Macy, would be able to contact you. So you're free to, all right, you're free to go, and you have a blessed day. Mr. Macy, you can call your next witness.
No, that's right.
Defense rest. State, do you have any rebuttal testimony?
No, Your Honor.
Okay. Ladies and gentlemen of the jury, both the state and the defense have rested their cases. And so the court has to prepare a charge for you. We will have what is called a charge conference. The attorneys and myself to go over the charge to make sure that everyone is in agreement with what you're going to charge. And then after we have that charge conference, we're going to call you back in. I will read the charge to you. And then both the state and the defense will have their closing statements. The state has the right to open and close. Okay? So at this time, we will ask that you exit the courtroom. And as the jury exits the courtroom, everyone please stand. Just have a seat in the hallway. Court will be in recess. Let's have our charge conference.
All right.
Okay.
Mr. Faulkner.
Oh. You may be seated. Let the record reflect that the court is back in session in cause number 323227. Case is styled the state of Texas versus Samuel Hayden Falk. Let the record also reflect that Mr. Falk is present in the courtroom with his attorney, Attorney John Macy. State is present with Assistant District Attorneys, Attorney Kyle Gasper, and Attorney Andrew Hubel. Let the record reflect that the jury is now present and seated in the courtroom. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
This is right.
Okay. Okay, now we'll proceed at this time with the reading of the charge of the court. Members of the jury, what,
Oh, I'm sorry.
you may be seated. Members of the jury, the defendant Samuel Hayden Falk stands charged by information with the offense of being intoxicated while driving or operating a motor vehicle in a public place. The offense is alleged to have been to have occurred on or about the 11th day of May 2019 in Jefferson County, Texas. The defendant has entered a plea of not guilty. Our law provides that a person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. A person is deemed to be intoxicated within the meaning of the law when such person does not have the normal use of physical or mental faculties by reason of introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of at least two of these substances, or any other substance into the body, or by having an alcohol concentration of 0.08 or more. A public place means any place which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office buildings, transport facilities, and shops. Now, if you find from the evidence beyond a reasonable doubt that on or about the 11th day of May of 2019 in Jefferson County, Texas, the defendant Samuel Hayden Falk was intoxicated, while so intoxicated did drive or operate a motor vehicle in a public place in Jefferson County, Texas. Then you will find the defendant guilty, unless you find beyond a reasonable doubt, or if you have reasonable doubt thereof, you will find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives no rise to inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty. It must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question a bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to the fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. After the attorneys present their arguments, you will retire, select a full person, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you believe they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous verdict or unanimous decision, your foreperson should sign the appropriate verdict page attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. Now, the last page is the verdict page. You'll notice that there are two lines. Your foreperson will sign on one of the two lines. The top line states, "We, the jury, find the defendant not guilty as charged in the information of driving while intoxicated." If that is your verdict, then your foreperson will sign on this line. Or, if your verdict is, "We, the jury, find the defendant guilty as charged in the information of driving while intoxicated," then your foreperson will sign on the bottom line. Does everyone understand? State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
This is good.
Okay, state, you have the right to open and close. Ms. Gasper,
State waives the right to open and reserves the right.
okay? And is 15 minutes enough for closing, or do you need additional time?
That should be fine.
Mr.
I
Mason?
believe that should be fine, Judge.
Well, what I do, I give you 20, just in case you, all right. Mr. Macy, you may proceed.
Good afternoon. Ladies and gentlemen, again, I'm John Macy. I'm sure heard that, probably thinking, listen to me, but I appreciate, and I know that the state and the judge and everybody here appreciates y'all's attention and y'all's diligence in being here for the last 4 days. Obviously, I have a different way of looking at the case than the state does, and I'll explain to you why I think that they didn't prove beyond a reasonable doubt that Samuel is guilty. And while intoxicated, first thing was that, as you recall, now, some of the evidence you have is that was introduced was the videos. You can see what the officer saw. You have the right to take those and look at them if you want. You don't have to. But notice when the officer got there, the first thing he did was he said, you know, something like, "Well, are you okay? What's your name?" "I'm Samuel Paul." "You have a driver's license?" "No, I don't. But my driver's license number is blah, 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 blah." "Okay. How do you feel?" "Oh, I feel okay." And, you know, the officer characterized that as, "Oh, he's confused. He was this and that." I would submit to you that someone who's intoxicated in the amount that they're claiming is he couldn't have done. Couldn't have been that. And I would suggest to you that there's a reason, there's an alternative for their conclusion that he was intoxicated. You know, he had an accident. The officer thought that the ground was wet. I don't know why he left the road wet, quite frankly. The officer didn't know, I don't think, and there's no testimony about that, but we do know that he ended up leaving the roadway and hitting the tree so hard that it spun the car. And then the officer's surprised that he's confused, and dazed. I asked him, do you know whether he had a whiplash or not? No. You know whether he hit his head? No, I don't know. And so the officer made all these conclusions. Oh, he must be, he was intoxicated. Well, now, originally, he didn't think he was intoxicated. He thought it was a medical issue. Because he didn't smell the alcohol. And, you know, they want you to believe that Samuel had a blood alcohol level, or they're gonna say, oh, well, as long as we prove anything over a 0.08, then it was, that's good enough. And, oh, but look, it's, the machine said, some magic machine said it was higher than a 0.40. That's, and Miss Altamirano, I think it's her last name, who's the tech. She's like, well, you know, the reason it says higher, although I would never testify to anything because it would be unethical for me to say it was more than a 0.40 because that's what it was calibrated to, but that's what she put in her report. Higher than the 0.40. Why is it calibrated to that? Well, because it's unusual. We never see that high. They want you to believe that his alcohol level now all of a sudden was, oh, well, as long as it's more than 0.08, that's good enough. That's all we have to prove. Or they have to prove he lost the function of his mental or physical faculties because of the introduction of alcohol in his body. Not because he had a wreck, he had a whiplash. I don't know if anybody's ever had that or not. I don't know if anybody's ever had head trauma, but I would submit to you that he was more or less fine, except for the fact that he hurt. He thought he was okay until the officer tried to get him to get out of the car. And then when he went to do that, he realized, wait a minute, that hurts. And to the officer's credit, he's like, I'm gonna change my call from, yeah, send an ambulance because there was an accident to, oh, send an ambulance in a hurry because he may be injured. Gotta give the officer credit for that. But, you know, would somebody that is intoxicated as they're claiming Samuel was, to be able to have those functions? Now, the officer saw some things, and I question him about that, because he made presumptions that, you know, well, yeah, I thought he was drunk because he was trying to turn the car off. He presumed, because he was messing with the key. Well, that was after he told him to get out. So maybe Samuel was just trying to get the key out of the car, couldn't do it. And the officer mistook that as a clue. Because remember, that's what he's looking for. A clue to put in his theory that he formulated later, by the way, that, oh, maybe I need to test Samuel, see if he's intoxicated. And all of a sudden, and you saw it on the video, and you can watch it again, Samuel was doing reasonably well. And then the officer, Samuel was hitting, he was telling him to get out. He tried to rush him out. And Samuel was hitting the display on the, we don't know why. But the officer, he was being impatient. He's like, no, don't do that. He must be doing that because that must be a clue that he's intoxicated or something. I don't know how he made that stretch, okay? But Samuel was doing reasonably fine, and look, you can look at the video, until all of a sudden, the officer shined a light in his face, bright, that light was bright, and he's shining it on stuff in the car. Look how bright it is. And the moment all of a sudden he does that, Samuel's face goes blank. Why? You're gonna say, well, it's because he's intoxicated. Maybe, but maybe it's because he had a head trauma. He was just in an accident. So was he intoxicated? Was there an alternative reason for that? Appearance of all of a sudden being dazed. So then, and remember, the first thing he did was he said, have you been drinking? And he said, no. Have you been taking drugs? No. Have you been taking prescription medication? No. And then he furthered the investigation, and he went and he started talking to Officer Smith, Sergeant Smith, I'm sorry, he was his supervisor because it was his first DWI. And he goes, I don't know what, exactly what's going on. We're trying to, he just gave me permission to search his vehicle. And he said, well, you think we should charge him or investigate him for DWI? Sergeant, of course. He's like, well, I don't smell any alcohol. If somebody had been drinking, but remember, you had testimony from his mother. His mother wasn't trying to lie about anything. She was trying to tell the truth. If she couldn't remember, she told what she saw. And she was with him most of the day, and he wasn't drinking when he was in her presence. And he was in her presence until 9:30 or 10, and this happened at 11:45. So question is, could he have drank that much alcohol in that short period of time to have a blood alcohol of intoxication level and the officer not be able to see? And I would submit to you that he couldn't. And if you think he might have, yeah, maybe he might have. But is there a reasonable doubt about that? I think there is. And if you have a reasonable doubt about his being intoxicated, then your verdict has to be not guilty. Remember that they took him, and the officer thought, well, I don't think he was drinking. So maybe I should investigate him or charge him with a DUI. Remember he said that. Because he was new. And, DUI stands for driving under the influence, which in his mind that, oh, maybe he's driving erratically, maybe he's on drugs. Because I don't think he's a DWI because it's smelling alcohol. But in the state of Texas, DWI includes drinking or being intoxicated by drinking or being intoxicated on drugs or a combination of the two. So the officer he wasn't sure. He thought, well, I guess it's a DUI if it's not medical because I don't smell any alcohol. And then Sergeant Smith corrected. Rightfully, but no, well, in Texas, it's a DWI regardless of what caused the intoxication. So then they went to the hospital. And he followed him to the hospital. And I kind of argued with him about this because I say argued with him. I was trying to point out the fact that he only did one of the 3 field sobriety tests. Manually, I would submit to you, He's supposed to do all three, but he didn't. And he had a good explanation for that, and I accept that explanation, if he wanted Samuel to be safe. My problem is with his conclusion. That Samuel automatically was intoxicated. And he marked the stuff, all he had slurred speech. Well, Samuel, had teeth problems, he was complaining about it, the officer even admitted in the hospital. So, yeah, I know, your mouth hurt. That's why you got slurred speech. Sam was talking about slurred speech. He was even talking like this with his finger in his mouth at some time, which didn't help. I mean, slurred speech. They were talking about good and bad blood kits at some point when they were on the scene, Sergeant Smith. And make sure you get the good, the blood kit that's not expired, right? And so that's part of the evidence, blood kits right there. It's got a date on it of expiration. So they're gonna want you to make that leap. Oh, if it says that it was not expired, that means there's nothing wrong with it. But is that what it means? I don't know. I don't know why this blood kit that when they took Samuel's blood and put it in there, and then I don't know what happened between the time that the officer put it in the refrigerator at the police station. We don't even know how it got from there to the drug net, because they didn't have anybody testifying about that. How did he get there? Where did it come from? Only thing I could ask Miss Alvarado, I'm probably butchering her name, was because she said, I tested it, looked like it wasn't tampered with, and I ran the test, and I used this fancy machine, and this is what it came out, and it said this was the. And I said, well, you tested it a week later, or thereabouts, whatever it was. And I asked her, is it possible for the alcohol to increase? And she's like, oh, no, it's designed to usually maybe go down. So I asked her about that. I said, well, what do you mean? When you said usually, well, most of the time, or whatever she said, you heard her. She was going out of her way to make sure she didn't agree with what I was saying, right? Because all I was asking her was, is it possible that once the blood got in there to the tube and sat in there for a week, it's impossible that the alcohol could increase? And she didn't want to admit it. She just wanted to say, no, most of the time it goes down. Well, if most of the time it goes down, maybe it's possible that it goes up. And we don't know. I don't know why it was as high as it was. Maybe somehow he drank so much alcohol in an hour and 45 minutes or whatever that once he had the accident, because that's when it matters. Was he intoxicated at the time he was driving? He stopped driving at 11:45 on the 11th. Right? They took the blood at 2:19, according to their records, on the 12th. 2.5 hours or so later. So during that 2.5 hour time, I don't know what happened. I mean, I saw, the nurse Armstrong about that. I said, there's guidelines that DPS puts out there to say, well, when you're doing this, you're supposed to do it this way. By using this special swab to make sure that you're not introducing any alcohol. He said, well, I use that iodine. So he didn't use the thing that they told him that he was supposed to use. He used something else. I don't know. I'm not a nurse. But I'm presuming there's a reason why DBS chose the procedure that they chose. And the nurse didn't follow. The nurse followed something else. Maybe the guidelines of the hospital. Did the iodine, I don't know, did it introduce alcohol into the blood? I don't know. I'm not sure. But could it have? I don't know. That's something you have to decide. You're the ones that decide what the facts are and what happened. But the officer came to the conclusion that he must have been intoxicated because he said had slurred speech. He was confused, which must mean that he was intoxicated, not that he just had an accident. But he was unable to follow directions. But he wasn't clear on when that was. Was it because he couldn't put his shoe on because he hurt because he was just in an accident? Or what directions don't you like?
Mr. Macy, you've taken 19 minutes.
Think said he was overly excited. Well, he gave me HGN and one standard field sobriety test, and based on that, he concluded that somehow he was entitled to get a warrant. And I would submit to you, I'm kind of out of time, but consider the case, look at it all. If you have any doubt that's reasonable, I mean, you're reasonable people. So if you have a doubt that's reasonable, then I think that you have to find him not guilty. And I appreciate your time and appreciate listening to me. Look forward to it.
Ms. Gasper, you may proceed.
Thank you, Tom. May it please the court,
Yes.
counsel. Good afternoon, ladies and gentlemen. I know it's been a while since we've spoken face to face. I talked to you all on Monday. I'm gonna finish it out before y'all are sent away to deliberate on the case that we've been talking about for the last 4 days. And like Mr. Macy said, we really appreciate you being here and being attentive and listening to what we have to tell you. And I hope that you've learned something during this process. Now, we all have heard a lot of information, facts, evidence over the last 3 days. And we talked even more about different topics when y'all were out in the gallery during voir dire. And in voir dire, you might have remembered that I asked specifically, maybe not so specifically you, but maybe your colleagues, what type of evidence you'd want to see in the case. And the answer varied. People wanted to see body cam, wanted to see blood draws, people wanted to see maybe eyewitness statements, that type of stuff. We also talked about what type of witnesses you'd want to see. We wanted to see from police officers, eyewitnesses, people like that. Well, ladies and gentlemen, here we are at the end of this case. And I think we've provided you with that checklist of items that you wanted to see on Monday. And we've provided the evidence through that and more to prove beyond a reasonable doubt that on or about May 11th, 2019, in Jefferson County, Texas, The defendant operated a motor vehicle while intoxicated in a public place. We also talked in voir dire about what it meant to be intoxicated, and you've heard and seen the definitions and mentions of what intoxication means under the state. And there are three definitions. We have loss of mental faculties, we have loss of physical faculties, and you have a BAC of 0.08. And if y'all remember back to when y'all were sitting out there and I was up talking, I mentioned that the state, to meet their burden of proof, only has to prove one of those types of intoxication beyond a reasonable doubt. Ladies and gentlemen, I submit to you that we have proven all three. I submit to you that we've proven beyond a reasonable doubt that the defendant had loss of his mental faculties. You heard on the body cam, you saw it yourself, and you're welcome to watch it again. You'll have access to that in just a little bit. You heard that his speech was confused and jumbled and wasn't quite making sense. You heard the officer ask him multiple times for clarification, and sometimes on the video, he didn't fully get clarification. And I submit to you that that proves beyond a reasonable doubt the defendant had a loss of mental faculties and that the defendant was intoxicated. Additionally, you saw the defendant on the body cam. You saw him at the scene of the crash. You saw him in the hospital. You saw his movements, how they were jittery, maybe not traditional movements that people make in everyday life. And you saw him lose the normal working function of his mouth at one point or another. And defense counsel wants to argue that maybe the defendant had a head trauma. Now, to address that, the officers were worried about medical issues. There was a crash. They have to do their job and keep people safe. Part of keeping people safe is to call EMS and have the people that were involved in the accident checked out, regardless of whether or not they think that the driver was intoxicated, regardless of whether they think anything illegal is going on, they have the people checked out. And you heard from the officers and you saw on the body cam that they did that. They had EMS come to the scene, they examined him on the scene, and they took him to the hospital for further inspection. Now, you also heard the officers testify that they transported him to the jail later that night or early that next morning, depending on how you want to think about it, and that he was medically cleared to be transported to the jail. Now, I submit to you that that alludes to a loss of mental and physical faculties due to intoxication. The defendant did not have normal use of his mental and physical faculties due to intoxication. Now, finally, y'all heard from the nurse who drew the blood, and you heard from Memling, the analyst that tested the blood in the lab and drew a lovely demonstration on the board for everybody. I know that that was helpful for me because I'm not a scientist. And you heard and saw from the report that the defendant had a blood alcohol content when it was tested at the lab of greater than 0.08. Not only was it greater than 0.08, it was over 0.40, and their machine was not calibrated because it's rare. Now, it may have been rare, but it does not mean that it's impossible. And she explained that to you during her testimony. She explained why the scientific method that they use in the lab is the way that it is. And she explained that she came to her conclusion because the machine was properly calibrated and they run the test. You heard about all the tests that they do on the blood to make sure that they're testing them accurately and that each sample is going through it properly. They use the samples that they have as the controls. I think that was the word that she used. And the blood kit was tested and it produced a result of greater than 0.08. It was greater than 0.40. The defendant was intoxicated because his blood was over legal limit of 0.08. Now, you also heard from Mr. Vickers, who was the first person that took the stand. He wasn't on the stand very long, but he was asleep and he heard a crash and he went to observe, and there was a car in his backyard up against his house, running into a tree or a table. And he had to go into the car and take the keys out because the defendant could not do so, alluding to the fact that the defendant was at a loss of physical and mental faculties or intoxicated, depending on how you want to look at it. And the officer observed all this. The officer made all of their conclusions. You saw, as Mr. Macy said, you saw what the officer saw. You saw the body cam footage. You saw the entirety of the body cam footage up until the officer left the hospital to go and get the blood warrant. You saw the totality of the circumstances that he used in making his decision to treat this as a driving while intoxicated case. You saw all the evidence that he observed, and now you get the chance to weigh that evidence in coming to your own observation that the defendant was intoxicated while operating a motor vehicle in a public place. You also heard from Sergeant Timothy Smith, who did the crash report at the scene. And I don't know if y'all could see very clearly, but on the crash report, there's a little diagram, and it showed that the defendant left public roadway where he was driving, spun out and ended up in a backyard. He was in a public place, he was intoxicated, and he was operating a motor vehicle. Ladies and gentlemen, I submit to you that we have proven far beyond a reasonable doubt that the defendant committed the offense of driving while intoxicated. I want to talk back to voir dire one more time. I mentioned when I was up there on Monday that y'all have a duty as jurors. In this case and any other case that you might be a part of. And your duty is to decide the facts, apply the facts to the law, and follow the law. And in just a few minutes, when you get to go back there and deliberate and talk amongst yourselves and come to a conclusion on this case, you will have the law in front of you. You'll be able to reference it as much as you want. If you have any sort of question, you can write it down, ask the bailiff, and he'll come and get an answer for you. You have the law. It is your duty as jurors to follow it. And I'm confident that once you come to a decision and we reconvene here to hear what your decision is, you will find the defendant guilty of driving while intoxicated beyond a reasonable doubt. Thank you so much for your time this week. I've really enjoyed presenting this case.
Ladies and gentlemen of the jury, at this time, all the evidence is before you. The court's charge and the closing arguments are before you. I'm going to hand the bailiff the charge together with the verdict form. They will be left with you in the jury room as you deliberate. Once all members of your jury are present and assembled in the jury room, the case is formally submitted to you and you will begin your deliberation. Now, before you step down, it was mentioned to you on voir dire that in a misdemeanor case, there are 6 jurors. If you notice, there are 7 in the jury box. That is because one person in the jury is an alternate. Now, the alternate does not go into the jury room with the other 6 members. And if something happens, then the alternate juror will go into the jury room to complete the deliberation. And so the alternate in this case is Miss Barbara Smith. Who is Miss Smith? Okay, Miss Smith. Okay. Now, Miss Smith, you will not be allowed to go into the jury room. However, you can remain in the courtroom or you can remain in the hallway. You just have to stay nearby in case something happens and we need an alternate juror to come in for someone else. Okay, so at this time, we're going to ask everyone, with the exception of Ms. Smith, to just please follow the bailiff into the jury room. And we will stand in recess until the jury reaches a verdict. State, are you ready?
It's ready, Your Honor.
Defense, are you ready?
This is ready now.
Let the record reflect that the attorney for the state and attorney for defendant are present in the courtroom. I have received a message from the jury that it has reached a verdict. Will a bailiff please bring in the jury? Everyone, please stand. Everyone may be seated. Let the record reflect that the attorney for the state, the attorney for the defendant and all members of the jury are present and seated in the courtroom. Foreperson, have you reached a verdict in this case?
Yes, sir.
Is it a verdict that is unanimous, that is one that is agreed upon by all the jurors?
Yes, sir.
Would you please hand the charge and the verdict page to the bailiff? Mr. Falk, would you please stand? Mr. Foreman, is the verdict unanimous? Is it a unanimous verdict with all members of the jury?
Yes, sir.
Okay, you may be seated.
Yes, sir.
We, the jury, find the defendant guilty as charged in the information of driving while intoxicated. Okay, you may be seated. Now, Mr. Falk, the court will be doing the punishment. Is that correct, Mr. Macy?
Yes, Your Honor.
Okay, so since the court will be doing the punishment, the court is going to order that a pre-sentence investigation be drafted by the probation department. So we have to reset this case for sentencing. Give us a date. Give it at least 30 days, no less than 30 days. December the 2nd. It can't be in October. I mean, in November. Oh, just said it.
Second, Your Honor. I have no objection to the second.
Would it?
November 25th.
Well, just put it in December.
Okay,
Like
that's
you have-
probably December 2nd.
December 2nd, okay. It would be on it could be on an announcement docket. Okay, Mr. Falk, your case will be reset for sentencing on on December 2nd of 2024. You'll be required to go to the probation office because the probation office will conduct the pre-sentence investigation report. You'll probably go to the probation office and they'll give you a time for you to report so that you can give them you make an appointment with them so that they can get all the information that they need. And once they get that information from you, they will draft that information up and send a report to the court. The court will give a report to your attorney and to the prosecution. Okay? So, at this time, ladies and gentlemen of the jury, first of all, on behalf of the citizens here in Jefferson County, and behalf of County Court at Law Number 2 staff, I'd like to thank you for taking time out from your busy schedules to be here, these last 4 days. I know that the decision that you had to make was a hard decision, but without people like you who take time out from your busy schedules, we cannot perform our duties in the courtroom. And so, again, I'd like to thank you for taking time out from your busy schedules. Now, I think the district clerk's office is still open. And so if you need to get anything from the district clerk's office, you can do that. And if you need like a work excuse, we have our receptionist who is behind the blue doors. The blue doors is actually, if you walk outside, it's right to the left of this courtroom. You walk down that hall, she'll be sitting behind a glass window. If you want an excuse, she can give you an excuse. And as I mentioned to the other members who are on the panel, anytime that you're in this area of Jefferson County Court at Law Number 2, you could come and have a seat in your courtroom. And as I mentioned to you earlier, the reason why I say it's your courtroom is not my courtroom. I know that when you came to court on Monday, you probably said, oh, I'm in the right place. When you looked over the top of the door, you saw County Court at Law Number 2, Judge Terrence L. Holmes. You know, this is Judge Holmes. But well, this is not my court. I'm only a public servant who's serving the citizens of Jefferson County. So I'm serving each and every one of you, working in your courthouse. And so anytime that you're in this area, you can have a seat in your courtroom in that area back there that we call the gallery. We call it the peanut gallery. But as I mentioned to you earlier, you can't bring peanuts in here and eat because this is not the Texas Roadhouse. And so anytime that you're in this area, you can come and have a seat in County Court at Law Number 2. Now, your jury service is complete. You can take your badges off. The lawyers might want to talk to you in the hallway. It's your choice. You can talk to them if you want to. If you don't want to talk to them, you don't have to talk to them. Okay? That's your choice. But anyway, your jury services are complete. And as I mentioned to the members of the panel, the last time that, I usually give a handshake, but, we still have COVID in our community. So at this time, I will give each and every one of you an air handshake. So, all right. Give everyone an air handshake. Okay. And so again, your services are complete. You have your letters from the bailiff. If you do not have any questions, you're free to go. And thank you. And each and every one of you have a blessed day. Okay. And I think I saw her at the Roadhouse last week. All right. Here you go. Jefferson County Court at Law Number 2 has now completed the case. Cause number M323-227, case State of Texas versus Samuel Hayden Falk. Court will be in recess until tomorrow for our bench trial. Everyone have a blessed day. Prosecutors, you're excused. And defense attorney, you're excused too. Y'all have a blessed day.